everyone. Today on the program, we have a lady from the Justice Center for Constitutional Freedom. She's lawyer Allison Pejovic. Allison is a person I've known for about a year now. I've never actually met her because she lives and works in Manitoba and I'm based in Alberta. But I've had the opportunity to get to know her a little bit. She's someone I have a great deal of respect for. And she is involved in handling a number of important high-profile human rights, civil liberties cases on behalf of the Justice Center for Constitutional Freedoms. So we have her on the program today to talk about some of the work that she's doing on behalf of Canadians who are suffering under a situation where their rights have been violated, in particular by government, where their human rights and civil liberties are triggered, which is the role of the Justice Center for Constitutional Freedoms. We're going to get her to talk more about that, and hopefully we'll learn some more about some of the important cases that she's handling on behalf of the Justice Center. So before we turn to her and introduce her, as we always do, we've got a few quotations that are meant to frame our discussion. The first one is a person who we often quote on this program, an intellectual whom I admire very much. Is Dr. Thomas Sowell, who is a brilliant economist who works out of the Hoover Institute at Stanford in California. And he famously wrote, "It is hard to imagine a more stupid or more dangerous way of making decisions than by putting those decisions in the hands of people who pay no price for being wrong." He was speaking specifically about government. Secondly, one from Albert Einstein, another person who's quoted often on the program, who once wrote that blind belief in authority is the greatest enemy of truth. Finally, again, someone who I admire very much, an author, one of the most famous 20th century authors, known best for his Narnia series, and that's C.S. Lewis. And he once wrote this: "Of all tyrannies, a tyranny exercised for the good of its victims may be the most oppressive. It may be better to live under robber barons than under omnipotent moral busybodies. The robber baron's cruelty may sometimes sleep, his cupidity may at some point be satiated, but those who torment us for our own good will torment us without end, for they do so with the approval of their own conscience." So, who do we have on the program today? Allison graduated from law school at University of Ottawa in 2003 and was called to the Bar of Manitoba in 2004. She articled and practiced in the litigation department of a large full-service law firm in Winnipeg for 5 years. In 2008, Allison moved to Toronto to pursue a master's degree in environmental law and policy from the University of Toronto. Her master's thesis, Freshwater Law and Game Theory, Strategies for Navigating the Troubled Waters of a Canada-U.S. Bulk Water Export Conflict, was published in the peer-reviewed Queen's Law Journal in 2010. After completing her master's degree, Allison was called to the Bar of Ontario in 2009 and spent a year at a leading national law firm in Toronto. Allison returned to Winnipeg in 2011 and spent the next 9 years as a Crown Counsel, arguing charter motions and other constitutional legal issues before every level of court in Manitoba and the Canada Labour Board. Allison joined the Justice Center for Constitutional Freedoms in 2020 and has been excited to advocate for justice and the protection of personal rights and freedoms. She is most passionate about parental rights and believes that everyone is autonomous and deserving of liberty and independence in inherently personal matters. Welcome to the program, Allison.
Thank you very much, Leighton. It's great to be here.
All right, and it's great to have you here. As you know, I've wanted to have you on the program for a long time, but you're so busy fighting all these cases that we managed to carve out a little piece of your time, and here you are, and we're grateful to have you here.
Yes, thank you.
Yeah, so you were a Crown. One of the things I want to ask you about, just in terms of your background, is obviously you've got this very intellectual, specific background in environmental law, and then you were a Crown Counsel lawyer for many years. So what sort of drew you away from that type of work, working for the government, to let's say the other side of the courtroom, where most of the time you're up against them? What sort of drew you over there?
Well, at the time, we were right in sort of the first year of the COVID lockdowns.
Hmm.
And right when that started in March of 2020, I saw the public health response to COVID, which was, it was unknown as to really how serious COVID was at the time. And everyone was sort of, it was a big question mark. And so they were taking a cautious approach in doing some very, for our society, radical things, closing businesses and closing churches and just keeping everyone home. And as time wore on, and I realized that this wasn't going to be just a couple of weeks, that this was going on and on, I started to get kind of alarm bells going off. Something wasn't right here, and I could sort of see and foresee what may be coming, and that this wasn't going to go away. And I can see, people are being affected by the virus, which was tragic, and people are also being affected by the measures, which was also extremely problematic. And sometimes with big events like this, all you hear about in the media is one side of the story. And there were a lot of stories that people were passing along to me, and I'd sort of heard about how these measures were really hurting people. And I could just see that there were people who were going to be asking for representation and who wanted their side of the story to get before the courts to determine, really, is this necessary to have these sweeping measures that are seemingly not going to end anytime soon. And so, at the job at the Justice Center came about. I was thinking of, at the time, perhaps leaving Manitoba, or being able to leave Manitoba to go somewhere else. I'm still here, but at the time, it was a family decision that we had hoped to perhaps move somewhere else, or to have the freedom to do so. And what's interesting about my job at the Justice Center is that I could live anywhere in Canada and just take my laptop with me and work wherever. It's a unique position in that you don't have to be situated in any specific province. You don't have to be in Alberta, where the head office is. So that was attractive for me. But I had also met Jay Cameron, who was litigation director at the Justice Center. We had a file together when I was working for the government. And we had a file together in 2017. He was representing an individual who was a kind of a born-again Christian biker who felt that his religious rights and freedoms were being violated by a government policy, such that if he was a marriage commissioner, and if he wanted to continue being a marriage commissioner, he had to marry any homosexual couple who called him to ask, will you marry me? And so it was a very, very interesting, and perhaps the most interesting case I had done as a Crown Counsel in government, where I was advocating for equality rights on behalf of the government, and Mr. Cameron was advocating for religious rights and freedoms, and it was sort of an intersection of those two separate rights, and it was very interesting. And I had a really great working relationship with Mr. Cameron, even though he was on the other side. He was very passionate about what he was doing, and I found it, very, very interesting issues, and a different side of the charter than I had been. I hadn't been litigating freedom of religion or equality rights to date at that point. I had been doing a lot of constitutional work using sections of the charter that pertain to criminal law. So when someone's pulled over by the police, can the police search your car? And the rights to privacy, arbitrary detention. So I was doing a lot of work with the crown attorneys in Manitoba, and I found that work to be very fulfilling. And I have nothing bad to say about my time at the government. I thought it was excellent work and excellent experience. But as I said, after having gone through the first few months of the COVID response, I was concerned as to the scale of the response and the fact that it didn't seem to be ending. That the public health officials, kept speaking as though this was going to continue, and as we know, the lockdowns got harsher and harsher at the end of 2020. And so I had my experience with Mr. Cameron and really enjoying, the work that I was doing, even on the other side, but it was interesting work. He was a passionate person and, very, very, it wasn't just a case for him. It was something that he was very, very interested in. And it sort of resonated with me, some of the issues and the cases that I knew that he was working on. So when the opportunity came, I thought, this might be a interesting and good time for me to go on the other side, because I could see the potential for clients on mass needing representation to go after some of these public health orders, which in Manitoba at the time were becoming more and more stringent. And I as much as I felt very sorry for all the people suffering with COVID, I really felt that there were other people, in the restaurant business, or pastors at churches, congregants, and others who were really being affected mentally, financially by some of these public health orders. And I knew that in reading what I had read about some of the science, I wasn't quite sure whether the science was there to justify the magnitude of the measures. There wasn't a lot of room for, in my view, could there be another way to do this other than shutting everything down? There didn't seem to be much of a willingness to look at other options from my point of view. And so I wanted to explore that from the other side and just sort of take a look at, what does the science say, and are these measures justified? And it was really interesting to me and very important to me to be able to have a court look at all of the facts and all the evidence and make determinations on whether this was necessary, whether it was reasonable, whether the science was actually there to support the really harsh measures undertaken by governments. And of course, it wasn't just Manitoba, it wasn't just Canada, it was happening all over the world, which was really unprecedented, that a global event would cause governments to react almost in unison in what they were doing and how they were responding. This was really unique. And I really felt that lawyers needed to be there to push back and take a look at what was the evidence. Let's see it. Let's hear from government, and let's ask them through the litigation to show the public what is the justification, and have a judge look at whether this was actually justifiable. And of course, I'm speaking in the context of a charter case, and that's what I've been doing, is litigating under the Charter of Rights and Freedoms. And when you're doing that, as you know, Leighton, because you do very similar, very important work like I do in terms of litigating on behalf of people who've been who say that their charter rights have been infringed. It's the onus is on the applicants, or the plaintiffs, to prove that the government has infringed their charter rights, such as rights to protest, freely express themselves, attend church, worship freely. Those are some of the examples. But once the applicants, plaintiffs can do that, then the government has the onus then to prove that those measures which have infringed our clients' rights are justifiable. And of course, there are very complicated but well-known legal tests that a court will have to go through and decide whether was this, was the measure rationally connected to the goal? What was the government's goal? And was there any other way that the government could have achieved its goal that wouldn't have impacted the claimants to such an extent? And what's the harms versus the benefits of the policy? So those are all factors that have to be weighed, and it really interested me and I thought it was very important to have that kind of analysis done by a judge, and not just in Manitoba, but across the country. And one of the things that attracted me to the Justice Center as well was the opportunity to litigate outside of Manitoba. And that's what I've been doing. I've had a very large case in Manitoba, which is still ongoing, but I've also been able to be virtually in courtrooms. I was in an Alberta courtroom virtually last week, and we've had cross-examinations in federal court, which so far everything's been online. So it's a wonderful opportunity to be able to meet lawyers from all across the country and to work on cases that I think are really, really important, because when governments across Canada are all in unison with very, very stringent policies, which are really unprecedented, there has to be somebody pushing back. And there are some lawyers that are doing so, but they are in the minority. And for me, I've always grown up feeling a strong sense of justice. Justice can be had on either side. And as I said, I really very proud of the work that I had done as a Crown Counsel with the province of Manitoba. But in this sense, I've really felt like there's been a lot of government overreach in the harshness and the duration of some of these policies. Not to say that we shouldn't do anything to protect people from a deadly virus. Absolutely. It's just that the reaction didn't seem to balance or consider what would happen to people mentally. I have had friends, family who've really suffered mentally, being forced to stay inside, not see family members for months on end. And so, you see reports of that, and that came through in our Manitoba lawsuit, where we sued the province of Manitoba. I was representing some churches, pastors, and a protester.
That's the Gateway case, correct?
That's the Gateway Bible case, yeah. So we really got into that. One of our experts was Dr. Jay Bhattacharya from Stanford University.
Well-known friend of the show, yes.
Yes. I think he was your first guest, and I know he's assisted you with one of your cases as well.
Yes, yeah.
But attached to his expert report, and he went through some of the mental harms. He's really, really a wonderful individual, very intelligent, brilliant man. And he was advocating for an alternative to lockdown, which is focused protection, as you know.
Mm-hmm.
And he's one of the authors of the Great Barrington Declaration, which advocated for protecting the elderly and those most vulnerable to COVID, as he's an epidemiologist and he examines these things on a daily basis at a very high university intellectual level. And, instead of locking everybody down, protect those that are most in need, and the virus will go through the population. We don't want people to get sick with COVID, but in some way there will be natural immunity, either at the time, he said, through either vaccination or through just people getting sick and recovering. And in that way, the elderly can be protected. So, that was what he was looking at. But as I said, he also went through his research on mental health issues, and we attached reports, Canadian reports of mental health crises in Canada, opioid crises in Canada and Manitoba. There was, I think it was an 89% increase in opioid deaths in 2020. And so that was acknowledged by the chief medical health officer in his cross-examination, that he was aware of that. That figure was released to the public in November of 2020. So, it's not one-sided, and we often, the media will portray the issue more often as we have to lock down the interview. They show quotes from physicians who are very pro-lockdown, but leaving out, not all the time, but from my experience, the majority of the time, leaving out the other opinions which are out there from other physicians who don't agree. And that's one of the things that I find really challenging working at the Justice Center, is because we are going against government, and the media, not all of the time, but a lot of the time, the mainstream media really does seem to come out in support of these government policies and leaving out the opposing views. And in science, there are always disagreements amongst scientific findings and what new studies say and research. And that's a good thing, because once scientists can discuss and go through studies and have debates, that fosters the progression of science. But when scientists are ignored, or the public only knows what some scientists are saying, and only the scientists that support what government is doing, the public isn't really aware of the other opinions. Mm-hmm. And so I think that's really one of the challenges, is that when you're involved in these lawsuits against government, the public is really often sometimes only aware of the one side of the story and what the science says in support of what government is doing, and unaware of the other side. So it kind of makes us, when the government, when the media reports on what we're doing, it makes us look like, maybe we really shouldn't be bringing these cases, because we're going up against government who's just trying to protect people. And governments are trying to protect people from COVID, but there's also consequences to that. And we're asking the court to weigh the benefits, weigh the risks, and weigh the harms. And so that's what we're doing. But when you have the media taking one side, a lot of the time, that's not all the time, but it's a lot of the time, it's challenging for us as lawyers, standing up for, quote unquote, the little guy in the courtroom, when you don't have the public's full awareness that there is really something here. There is another side of the story.
So, Allison, you were talking about some of the reasons why you made a very brave decision, I would say, to leave a safe, secure, comfortable government law position to move over to the Justice Center. But you did leave us hanging a little bit. We never did hear about what happened to the Christian biker. Who won that case?
Well, we won. The government won that case.
Of course. That's why you didn't say something, because you had an abundance of modesty. Okay.
No. No, it was a hard-fought case, and I have a lot of respect for Mr. Cameron. And we went to the Court of Appeal with it. And at the lower level, the Queen's Bench judge found that the government did not violate Mr. Kieslowski's freedom of religion. And at the Court of Appeal, they found that government did violate his freedom of religion, but that it was justified under Section 1 of the Charter. So, it was a really, really interesting case, my favorite case. And that's really what led me to consider other types of practice within the constitutional law realm. And so it was really, being put with Mr. Cameron, because, as I said, he's very, He was opposing counsel, but he was friendly and very dedicated to the cause. And I was
Right.
really intrigued as to the other kind of work that he was doing. And it just seemed really different, unique, and important. And I was
Mhm.
attracted to that kind of work as something different. As I said, I thought during the COVID lockdown, I could see the potential for many lawsuits um, challenging some of these measures and being very interested in the science. I was really I jumped at the opportunity to be able to lead some of those challenges, and I have to say, as challenging as that has been, because we are seen as the underdog, but we work very hard, and there's a large group of people in the country who depend on us to bring forward these cases and have them heard. I've had the opportunity to meet some amazing people from across the country and across the world that I never would have met before, and that is not only lawyers, but Canadians who are really desperate for someone to stand up for them in the face of some of these very harsh restrictive policies, whether it's public health orders or vaccine mandates. We'll get into that. But
Mhm.
some of the scientists and physicians that I've met who have been willing to do independent, impartial expert reports for us and for to help the judge assist the court in determining the reasonableness of some of the government's policies. I've really been it's really been very wonderful opportunity for me and my colleagues to get to know some really interesting and highly intelligent people who have a contrarian view and have a different view on the science from their own research and from going through peer reviewed studies and the raw data from the provinces and from around the world. And so these are people that I never would have had the opportunity to meet had I been working in Manitoba. But as I said, I have nothing bad to say about my time there. It was very fulfilling while I was there.
Well, let's dive in a little bit and talk about some of these cases. Now, I realize it's hard to sort of rate them or categorize them, but is there one that you've handled so far that you found has been the most gratifying one for you?
Yes, probably the most recent case that I argued in court with my colleague, Ms. Eva Chipiuk of the Justice Center. We represent a lady who is an Alberta resident who is suing the Alberta government and a group of physicians within a transplant program, and I can't reveal the name of the organ that she
Mhm.
needs to be transplanted due to a publication ban, and I can't name the doctors, but I can say it is a transplant program in the province of Alberta, and she has been denied a transplant because she's unwilling to receive the COVID-19 vaccination.
It's a life-saving procedure that's required, right?
Yes, unfortunately, she has a terminal illness and she needs the transplant to survive. And so she was in a hot, like it's called a status 2 waiting list, which is a waiting list for people who are in urgent need of a transplant. She followed all of the instructions of the transplant team, the doctors. She went through a whole bunch of tests, and it was determined that she was a good candidate for a transplant. And so she was hopeful that she would have a chance at a longer life and that her horrible disease she could be cured of that with the transplant and have a chance at survival. And then all of a sudden, the requirement to be vaccinated was communicated to her, and she's based on her conscience and she's argued that the physicians never fully explained all of the risks of the vaccines to her. She wasn't willing to take the vaccines, and for us, hearing her story, We felt it was extremely compelling and important to stand up for this brave woman, because not only have we seen in Canada people being barred from sporting events, restaurants, traveling on an airplane, which is egregious enough. Now here's a woman who's being denied life-saving surgery within a transplant program that otherwise she was eligible for.
She was wasn't she very high on the
Yes.
list?
Yes, she was. There's different levels of need, and she made it into a special list for people urgently in need. So she could have received a call at any time. And so, it's really heartbreaking to talk with her and to hear her interactions with her doctors, which she recorded a conversation where her doctor told her that she needed the vaccine to get her transplant. And she said, well, what do you mean? Like, what's going to happen to me if I don't get the transplant? And the doctor says, yes, I do know what's going to happen to you.
I had to listen to it. It was heart-wrenching.
Yeah. And so, she's so brave. She's standing there, before the court on her principles and on the basis of her conscience, saying, these doctors didn't explain the risks to me. Mm-hmm. They're asking me to make this decision while I'm under duress. And our argument is that that is a complete violation of her rights under the Charter of the right to liberty and security of the person. Mm-hmm. Because how can you make a free choice, a freely autonomous choice to put something into your body when the consequence to you, if you don't, is certain death? And so this is a very, controversial case because it has to do with the COVID-19 vaccines, but it's really about personal choice, free of duress, the right not to have your conscience violated. And her conscience is such that she believes that it's wrong to force someone to get a experimental medical procedure or face certain death. She believes that is a matter of right and wrong, and also that it's an infringement of her free will. Mm-hmm. And so the argument goes as well that it's an infringement of her right to life, not only because she will not survive if she doesn't follow through with the policy, but also if she does follow through with the policy and gets the vaccine, there is a chance, however small that may be, there is a chance that she could suffer a serious adverse event and she could die. And that fact was admitted by the expert called by the Alberta Health Services. They're expert in the safety and efficacy of the vaccines. He admitted that people have died from the vaccines, from blood clots, and from myocarditis. And, his evidence is that number is very small, but it is still a chance. And so for a government program to have a policy that requires someone to take a drug that could kill them in order for them to be eligible for life-saving surgery, in our view, that was something that was definitely worth putting before the court. Mm-hmm. And it's not like she's saying, I refuse to take the immunosuppressive medication after my transplant, which is actually necessary for her to survive. We're asking the court to consider that she may never get COVID. She doesn't have COVID. And are there other options? They never tested her to see if she was naturally immune. Mm-hmm. And they weren't willing to do that, to even explore whether she'd had COVID before. And the interesting thing about this case is that the transplant team was actually admitted that they're willing to transplant a unvaccinated person with a medical exemption to vaccination. And under cross-examination of one of those team members, I asked her, well, that unvaccinated person with a medical exemption is at the same risk of getting COVID after the transplant as my client, generally speaking, right?
Mhm.
Yes.
All things being equal.
Right? All things being equal, that person could die of COVID to the same extent, could spread it to someone else. It's basically the same. Their risk level for a serious outcome from COVID or to spread it is the same as my client who doesn't have a medical exemption. And the answer was yes. So they're allowing unvaccinated people to get the transplant if they've got a medical exemption, when the whole purpose of the program is to maximize the benefit from a scarce resource. And the purpose of the vaccine requirement, as set out in the affidavit from one of the physicians, was to ensure, to try to prevent a serious outcome from COVID and for prevent infection and a serious outcome from COVID. Well, how are either of those objectives achieved by allowing someone with a medical exemption who's unvaccinated from getting the transplant? So, the decision is going to be coming out in a couple of weeks. We've asked the court to find that our client's rights to life, liberty, and security protected under Section 7 of the Charter were not in accordance with the principles of fundamental justice. And it's a very complicated area of the Charter, but we can show that her rights to life, liberty, and security of the person are violated, but that's not the end of the analysis. We also have to show under Section 7 that such rights violations were either arbitrary, overbroad, or grossly disproportionate. And we've made all of those arguments, but that's our onus. And then, if the court agrees with us there, the court can still come back and say, well, the government can now try to show, and let's let them try to show, that this was justified under Section 1 of the Charter. And so, their argument is that, we're doing this to maximize the benefit from a scarce resource, which is the organ at issue. These organs are rare, and the family members want that transplanted organ to go to somebody who's most likely to survive longer term. And, we had expert evidence from Dr. Bonnie Millard, who is an award-winning immunologist at the University of Guelph, and she's been teaching immunology for 30 years. She's a PhD, and she did an amazing, in our view, an amazing expert report with dozens of peer-reviewed studies cited. She went through the raw data. She looked at the vaccine adverse event reporting system in the United States. She had some really compelling graphs in her expert report, and she basically explained, she said in cross-examination that she's not an anti-vaxxer, but she has concerns about these vaccines. And she really explained that these vaccines have more reported injuries than any other vaccine in the last 30 years combined. And that's just one element. She showed that they're still in clinical trials, and a lot of people don't realize that. And so when you say what we've said is they're experimental, and when you say that word experimental, you get this sort of visceral reaction from the other side. No, they're not experimental, is what you get back, because they've been injected into billions of people. Well, that's not the point from our perspective. The point is that they're still in the clinical trials, which are assessing the safety and efficacy of the vaccine. That's what the actual trial is called. It's called an assessment of the safety and efficacy of the different vaccines, and they're not finished. They're still in the phase 3 clinical trials until Moderna, I believe it was later this year, but at the earliest November 2022 is what the document referenced in Dr. Millard's report says. I heard that it's been pushed to later, but it's at the very earliest this November. Pfizer is not until 2023. And so, you've got these policies being made, forcing transplant candidates to take a drug that is still being tested for safety and efficacy for a condition they don't even have, may never have, or may get and not be negatively affected in order to survive. And for us as a charity law firm, that was a case that was really important to bring to the court. Because as I said, we're not only in the realm where we're talking about denying people access to travel, which is bad enough, or restaurants or other social activities. We're talking about somebody's life here, and you're willing to close the door on somebody's life and deny them life-saving surgery, which you earlier promised to them, and all because they haven't agreed to be part of this experiment. And I know that's controversial to say that, but I say that because the vaccines are still in clinical trials. And
Right.
for me, that means that it's an experiment. And I also am referring to the expert report of Dr. Bonnie Millard, where she says, until these vaccines are finished clinical trials, people that take them have chosen to be a part of the experiment, and that is their choice. But in this case, my client is told, yes, it's your choice, but if you make that choice, you will die. And that is extremely heart-wrenching, and in our view, it's cruel, and it ought to be weighed by a court. And so we're very thankful that the judge is willing to make a quick decision on this. And so we're going to get a decision in a couple of weeks. So we're really, really hoping that that our arguments were compelling and that our client will be given an opportunity to have a chance at life.
Well, I'm sure that the arguments were compelling. This case is a really fascinating one because even leaving aside the legal arguments that you've laid out quite clearly, we had Dr. Roger Hodkinson on the program, and he talked about the fact that the vaccines, then the way that they're being imposed, actually violates fundamental pillars of medical ethics as well. Going back to Hippocrates, he explained that there's two fundamental pillars upon which medical ethics are built. This goes back to the ancient Greeks. One of them is of course do no harm, and in the Lewis case, arguably already serious harm has been done. We don't know how the delay has impacted her health and perhaps prejudiced her chances of survival. She certainly suffered emotional and psychological harm, to say nothing of the physical effects of being on this waiting list for so long. But then there's the doctrine of informed consent that you've talked about. These two fundamental pillars, and because of what you said quite accurately about how experimental these drugs are, there really isn't anyone who can provide informed consent to taking them, is there? Because we don't know even the short-term impacts. We're just finding out, the Pfizer dump, people know about this, but we really don't know the long-term impacts, whether you call it long COVID or vaccine harms or whatever. We really don't know the long-term impacts of these drugs at all. And so in a real sense, it's not just legal issues that are involved here, but fundamentally, bioethics, medical ethics are being triggered in this case as well, aren't they?
Absolutely. And before I get into that too much, I do have to be fair and transparent in the sense that once we filed this originating application in the fall, the respondents, being AHS and the transplant program, they actually agreed to, they signed a consent order where they agreed that pending the outcome of the court case, they would not prevent our client from getting a transplant if the right organ came in while she's waiting for the decision. So unfortunately, she never received a call in these last few months from the transplant team that the right organ for her came in, but they did agree to leave that door open and that the policy wouldn't apply to her in the last few months. So just to be fair, that was what they agreed to. If we're unsuccessful if we're unsuccessful when the judge renders his decision, then it's our belief and understanding from the evidence that they will move her to a different status where they will not give her the transplant without her getting the vaccine. So I just want to clear that up. But in terms of bioethics, absolutely, we asked all of their experts to whether they agreed that there was no long-term safety data. And of course, what are they going to say?
Mhm.
The vaccines are so new, they really couldn't give any other answer than yes, there's no long-term safety data. And that is a very large factor. And we argued that aggressively in court. We've got years and years of safety data for the childhood vaccines, which our client agreed to get. There's no issue there with, I think, you say, well, there's a risk of X, Y, and Z. We know those risks, and are you willing to take that vaccine? And that's her choice to take the vaccines based on the known risks. And long-term safety data is very important. But what I find very interesting, and we really argued in front of the judge, is that when these vaccines first came out, you had the Prime Minister, public health officials on the camera basically saying, here are the vaccines, we're very excited about them, and go out and get whichever one is first available to you. Doesn't matter. The first vaccine that's available is the best one for you. Something like that. And people went out and got whatever was available. And, there were different vaccines that were available in different places. And then after Canadians had already got AstraZeneca vaccine, the issues with the blood clots became known, and that they weren't discovered in the clinical trials. And so then I believe in Manitoba, from my memory, Dr. Brent Rusin was on the camera saying, I believe he said that he got the AstraZeneca shot, and he was on the camera getting one. And then it was a couple of weeks later when the blood clot issue hit the media, and all of a sudden the public health officials are walking back from the AstraZeneca and saying, well, only people over, I think it was 55 were recommended to get it because of the blood clot risk for the lower age groups. It's been a while, but I think that's how it went. And then after that, you had a summer full of young males being encouraged to take whatever vaccine was available, Pfizer, Moderna. And then in the fall, the Ontario government actually put out a statement saying, actually, we don't recommend that young males take Moderna anymore because of the heightened risk of myocarditis that we've been seeing. And myocarditis is heart inflammation. And what I've learned from our experts on a different file, we worked with Dr. Peter McCullough on a different file, the travel mandate file. And it's his view that myocarditis should not be called mild. That mild, it may be referred to as mild because the young men are in the hospital and then get sent home, and the symptoms may be mild and they get sent home, and that, in his view, that is not a reason to call it mild. There could be long-term issues that are unresolved that we don't know about yet. And heart inflammation is never something that young people should have. And so for the governments in Canada to go out and encourage young males to get whatever vaccine is available, how many of those young males got the Moderna vaccine before the Ontario government said, actually, wait a minute, you better go get the Pfizer because the Moderna one is a little bit too risky. So those are examples of what we mean when we say there's no long-term safety data. We're still learning. Governments are still learning and hearing about new safety signals. The WHO, as an example, it came out in this Annette Lewis case, transplant case, is actually investigating links between the vaccines, COVID vaccines, and tinnitus and hearing loss.
Hmm.
And there's small number of reports of that, but it's a safety signal that they're investigating. And so this wasn't something that was known early on. And what I find ironic is that our client was told as late as November of 2021 that because she's concerned about the mRNA vaccines, that perhaps she should go and get the Johnson and Johnson vaccine. And in May of this year, the FDA put out a statement on its website saying, actually, due to persistent reports of blood clots, we're actually restricting its use.
Mm-hmm.
And the Canadian government has not put out the same statement, but the FDA has. And so, what about all those American people who just got the Johnson & Johnson vaccine in April of 2022, only to learn a month later that it's not recommended and it's being restricted? Mm-hmm. So this is all, as I said, it really goes to put a spotlight on the fact that these are so new. We don't have 10 years of safety data. Why are we mandating this for anyone, but especially withdrawing the chance for someone to get life-saving surgery because they don't want to take that chance. They don't want to take that risk, and they don't want to put themselves in a position where they could have unknown health effects later on that will eventually become apparent. But once it's not like taking Tylenol. If you take mm-hmm. Tylenol and on a weekly basis or something, and then you learn there's something wrong with Tylenol, well, you just stop taking it. Once you're injected with the vaccine, it's in you. So unlike the childhood vaccines, which are generally speaking proven to be safe, we've got this unknown and this question mark, and that's what we wanted the judge to see. We don't need the court to say the COVID vaccines are dangerous. The judge is never going to say that. But what we're asking for is an acknowledgement that there is a question mark here. There are risks that are unknown, and it really goes against the principles of fundamental justice to mandate an experimental drug with no long-term safety data that is still in clinical trials, and put that in the way, put that as a condition for someone to receive life-saving surgery. So, whether we win the case or lose the case, I feel that it was an important case to argue, and we've had a lot of inquiries from other people across the country who are waiting for transplants and have been told the same thing. So it's not just our client. This is right. An issue. We've had at least a dozen inquiries that are similar, and I've read about similar cases in the United States. And so it's really important, and I think it's sort of, as I said to the judge, we're really standing at the precipice here of what our society looks like. Mm-hmm. And if we're going to start denying life on the basis of a refusal to take a drug like this, that is at this stage of its development, mm-hmm. It's available for use, but we don't know the long-term safety effects. Is that charter compliant? Is that lawful? And we say no, and we say no very passionately, and we look forward to seeing the judge's rationale on this. And we, as I said, whatever happens, it was an important case to bring, mm-hmm. and we're really, the courage of our client really shone through in this case, and she stands for freedom. Like she's in a very unique position when she's standing up for personal rights and freedoms.
Sounds like she has a gutsy lawyer too. One wonders though what it's going to be like for people once the definition of fully vaccinated changes because of the recent announcement we heard from the federal health minister that people are going to have to be on these to be taking these drugs on a 9-month rotation. One wonders what impact that's going to have for all these poor people who are waiting Now it's not just 2 doses; they have to, submit to this regimen, and it kind of gets at a deeper issue. By way of segue, I want to get into talking about the Brian Peckford case. Brian Peckford, you might know, was a guest on this program. Really a brilliant, sterling man of keen intellect and prodigious memory. The case you just described, the Lewis case and this Peckford case, really gets at a trend that is frightening to me, but seems to be emerging. I would go further, is evidently emerging, to create separate classes of people in terms of human rights and civil rights and civil liberties in Canada based upon their approach, their receptiveness to vaccinations. And it almost is at the point where one could frame an argument that vaccination status is a euphemism for those who will comply and those who choose to dissent. So bringing us to Brian Peckford, there we've got a situation where, as you know, even now there's a ministerial order that's been, the effect of which has been suspended, but there's still a ministerial order in place that says that people who are not vaccinated cannot board trains or ships or airplanes in this country. And it sounds as though, from what the federal government is saying, all of that is going to be reinforced come the fall. But by way of segue into the Peckford case, I'd like you to talk about that one. I know you've been working on that one. It's a very high-profile one, or you've been working on with Keith Wilson, who is a friend of mine and colleague of mine. But in the Peckford case, and I'd like you to maybe comment on this. The Peckford case for me is a really key one because, and I spoke to Keith about this, the Section 6 mobility right was very carefully chosen as a, in terms of a right to base a charter challenge on, partly because it's such an obvious violation. It's so obvious that mobility rights are being violated there. But also, secondly, my understanding, and correct me if this is wrong, the Section 1 arguments that are often presented by government in these charter cases are comparatively weak in that context in terms of restricting travel. Would you agree with that and sort of answer that question and maybe explain a little bit more about what the Peckford case is about?
Yeah, absolutely. So Brian Peckford, the Honorable Brian Peckford, is one of the original authors of the Canadian Charter of Rights and Freedoms, and he is the last surviving author of the Charter. And so it's very symbolic for him to be standing up and suing the federal government, saying that his charter rights as an unvaccinated person have been violated. He lives on Vancouver Island, and his family, as he's outlined in his affidavit for the court, his family lives on the other side of the country in Newfoundland and Nova Scotia. And so he's unable to visit them unless he's willing to drive 7,000 kilometers one way. You can imagine how that will go over for a gentleman in his 70s wanting to visit his family at Christmas time. It's very difficult for him to do that, and that's representative of so many unvaccinated people in the country who are not able to visit loved ones who are dying, are not able to attend funerals, are not able to see their loved ones overseas. And so the restriction on travel affects people in different ways. One of our clients is not able to get to work, actually, because of the travel ban. He lives in Ontario, but his job is in the Northwest Territories, and he relied on WestJet to get him there a few times a year. And that was a lifestyle that he chose and that worked for his family. And ever since the travel ban, he's had to drive 5,000 kilometers in the north part of the country, which is very treacherous during snowstorms. And he said he nearly lost his life a couple of times in the horrendous winter weather. And so it's absolutely absurd that we've come to the point in the country where the government is preventing people from getting to work, from seeing loved ones, from seeing their families, and from leaving the country, period. I mean, what kind of democracy is it where Canadians can't leave the country? And the response may be, well, they can. We're not stopping them from driving somewhere. Well, how is a Canadian supposed to get to see their family in England, or in China, or in South Africa? One of our clients has family members who are ill in South Africa, and how is she supposed to get there? She can't drive. She'd have to take a boat or a plane, but that has, up until recently, when the travel ban was lifted, probably temporarily, how are people supposed to get there? Are they supposed to take a canoe? Like, it's absolutely absurd and ridiculous. And so, what's also ridiculous, if you think about it, is the orders never prevented Canadians from boarding aircraft to fly into the country, but they could get on the same plane and fly back out of the country. They can't take the same plane they were just on coming into Toronto, say, from England, but if they stayed on the plane, they would not be allowed to take off to leave. And the ridiculousness of that, and the scientific justification for that, I'm pretty confident that a judge is not going to rule that is scientific. There's, of course, so many legal elements and part of the legal test that has to be satisfied on both sides, our side and on their side. But just at a basic common sense level, it doesn't make sense that it's dangerous in terms of spreading COVID if you're flying into Canada and on the same plane you can't.
Is that the argument that the government is presenting in response to the Peckford challenge? That's the basis, that there's a safety issue there, and that's why this mandate has to be in place?
Well, it's sort of, we're not really, we'll have to see the written arguments. Certainly the public statements made by the Prime Minister early on last fall, when he was first announcing the upcoming travel mandate, which he eventually put into place, was that you're going to feel safer as a vaccinated person not having to sit beside unvaccinated people on an airplane. They're not going to infect you. So that was sort of a concern about a transmission argument. I guess we'll have to see how it's framed in the written arguments that we have not yet seen. But it could be, the argument could be that they want to prevent as many people from going into the hospital as possible. But in my view, I don't see the link there between stopping people from traveling and preventing people from and slowing down admissions to hospital, because, as you know, both vaccinated and unvaccinated people can get COVID, and they can and do spread it to other people. And so it's just the link there.
Even our Prime Minister.
Right? Yeah, exactly. You have the Prime Minister.
Most people like.
Yeah. A trip to California, comes back, has COVID. I think he said he's had his fourth booster. No, fourth. Yeah. 2 boosters, I guess. Fourth shot.
Yeah, and he's mostly alone in that private jet, I think. But that's
But anyway.
So you just went through a series of cross-examination of some witnesses in that case, though, didn't you, Allison? Could you tell us a little bit about how that went?
Yeah, I mean, I can't get into the specifics of what came out of the cross-examination.
Fair enough.
The transcripts are not filed, but we cross-examined their medical experts. They had Dr. Peter Liu, who's a cardiologist. He was put up against Dr. Peter McCullough, who was our expert cardiologist, who was in Texas. And that was basically focused on young males and myocarditis. And that was, very, very interesting, very focused part of the science here, because one of our clients is an 18-year-old college student in BC who can't, up until recently, when the mandates were lifted, couldn't fly back to Ontario to visit his family. And he's concerned, as he's outlined in his evidence, about what he's heard about potential heart inflammation, and he's an athlete as well. And there is some evidence that athletes that are higher risk of myocarditis from the vaccine. And so, these are very, very specific, important issues. We also have clients who want to get pregnant, and we had an expert gynecologist who said there's just no evidence to show that the vaccines are safe for pregnant women. She never came out to say that they are absolutely dangerous. That wasn't her evidence. Her evidence was it's unclear, and there are some concerns that she saw that needed to be explored further before she could say that they're safe for pregnant women. And of course, the government had a gynecologist on the other side saying the opposite. And so, the court is going to have to go. We will of course pick out our witnesses' arguments that are most compelling, and any sort of admissions from their witnesses that were most damaging for their arguments. We'll highlight those in our written materials, which we will be drafting very soon. The hearing has been moved, adjourned from September 19th until October 31st, but the government's also arguing that the case should not be heard at all because it's moot. And mootness, for those who aren't aware of what that means, is that they're arguing there's no point in arguing the case because the travel mandates have been lifted, and if they were put back in place, it would be based on new facts, such as 3 doses or more to get on an airplane. And our argument is that, be that as it may, even though the travel mandate is lifted, it's our position that this case has to be heard. We can't be chasing every new public health, we can't be chasing every new travel mandate, whether it's 3 doses, 4 doses, 5 doses, 6 doses. On principle, there has to be a ruling either way, whether the federal government can stop Canadians from leaving the country, period. There has to be a ruling on that. Whether, there's
very compelling
right?
mootness argument, is it? I mean, because my understanding is the order is still in place. It's only been suspended.
It's not enforced. So if they want to bring it back, they'll just make another one.
It's like a sort of Damocles.
Yeah,
so very strong argument.
Canadians need to know. There needs to be a precedent. They need to know either way, whether they're living in a country where it's lawful for the federal government to make an order that they cannot leave the country. Is that lawful or is it not? And if it is lawful, then Canadians have a decision to make whether they wish to stay here or move to somewhere where they can freely come and go as they please. And so that's a decision that Canadians deserve. They deserve to know whether that is lawful. And I mean, what's interesting is what Canadians' passports say. The passport says this document entitles the bearer to enter the country and leave the country without delay. And so it flies in the face of all of these requirements that Canadians now have to jump through hoops to get back in the country. The Arrive can happen. If you're unvaccinated, quarantining or submitting to PCR testing. Well, what about the passport says you're welcome to come back in without delay. And so, it's troubling where we seem to be going in the country in terms of all these increased restrictions and sort of extra measures that Canadians have to go through to be able to do what they've been doing for years. And all of a sudden there's these new, a lot of it is digital requirements, restrictions, and then you have the disaster at the Canadian airports. And whether that is from all of the unvaccinated workers who were let go, and whether they can't replace them, combination of that with whether it's the Arrive Can app or just delays from all the bureaucratic red tape that has been put in place for travelers, but it's making it very difficult to travel right now. And I just read a headline, it was yesterday, that show that of all the airlines
You saw that
across
one
the
too.
globe that have had the most delays last weekend, WestJet and Air Canada topped
Yeah,
the global delay on airline list.
that's not a good list to be at the top of, Allison.
Yeah, no, so it's, like we really, well, what my personal thoughts are, it's another matter, but
Sure.
it's really important. It's really important to push back
Right. That's the position.
and and have a judge go through the science and not just what somebody says on TV. That's what I found frustrating is what I've learned through going through the cases is what certain health officials or physicians that are speaking about the science in the mainstream news are sometimes saying things that are contradictory to what the peer-reviewed research and our expert reports say. So what we want is the court to examine all of the evidence and have that process of going through cross-examinations and determining really is what they're doing, is that actually justifiable based on the science and based on the evidence that comes out in the cross-examinations. And so but as I said, the ultimate arbiter will be the judges, and we're really hopeful that by putting in strong evidence and having a dedicated legal team, we can have the truth come out in court, whatever that truth may be. We want the court to make findings on the science, and it just seems don't want to minimalize, trivialize what's going on, but it really does seem silly that you, as a Canadian, could fly into Canada on a vehicle such as an airplane, and you couldn't leave on that same vehicle because it was not so dangerous coming in, but all of a sudden too dangerous to leave on. It just seems silly, to put it mildly.
Or that cabin loads airplanes full of Ukrainian people who are fleeing a war-torn country that has a 35% vaccination rate.
Yes.
Can land in Canada without any testing or any restrictions whatsoever, and so we sort of have this double standard. Now I hear what you're saying about you're hopeful that you'll get a judge who will make a rational decision. There are some signs of hope that we've seen in Alberta recently. I certainly hope that you get a judge in the Peckford case who is not going to say something as incoherent as the court cannot be expected to be an arbiter of science. But be that as it may. So you have been working on these very high-level cases, and you say you've been learning a lot about these different disciplines: epidemiology, economics, medicine, genetics, all these things. Do you find that is one of the biggest challenges that you face as a lawyer, just sort of the learning curve of becoming familiar, becoming conversant with these topics? Do you enjoy that? Do you enjoy that challenge, or is it one that you find very, very difficult to face on a daily basis?
No, I really love it. I wonder whether I should have tried my hand at medicine or gone into a scientific field, but I am a lawyer.
You're a lawyer.
I'm a lawyer, but
you're like a movie actor, right? A litigation. You step into these roles, right?
But when we do work with experts who are, as I said, providing their impartial opinions, we ask them questions about the science and to explain things to us. And I will be the first to admit, sometimes I'll read a study or an article linking to a study that I hear about, and I'll have an idea, and I'll have an idea of what I think it actually means, and then I'll ask the expert, well, does that actually mean that? Because I'm hoping to use an argument in court, and then the expert will say, no, it doesn't mean that at all. It means something else.
You too.
So it's really important. You never want to make an argument in court or ask an opposing expert a question based on a false premise that you had in your mind. So it's
Right.
really important to be working with experts who are not only willing to do a report on issues that you ask them about, but are willing to give you some extra time to explain, assist with understanding what the report actually means. And so I found that to be very, very useful, getting to know these really wonderful individuals who are brave enough to give their independent, impartial opinions, but sometimes those opinions go against the the scientific opinions that are highlighted and sort of propped up by some media outlets as being
Mhm.
sort of the
Mhm.
ones we should be following. And so it's a lot of physicians have been censored for having different views, and that's highly unfortunate and very troubling in Canada. But so it's finding experts who have opinions on different scientific issues that are different, or the ones that we've had in some of our cases, that once they've assessed the science, they come to a certain conclusion, which we're using in our arguments. It's very, very. I'm very lucky to have met some of these people, and the quality of their work is really impeccable. And I'm so impressed by the depth of knowledge that some of these scientists have. But what I've really tried to do as a lawyer is look at the other experts' studies, what they've cited, and it's been a challenge to read through and kind of look at trying to look at tables and on these very, very complicated scientific matters, tables, charts, percentages, conclusions, and that's where I pick up the phone and I say, "This study says this. Is
Mhm.
that actually what it means?" And sometimes I'm right, sometimes
Yeah.
I'm not. So
Yeah.
it's a, but I really thrive off of that challenge, and my favorite cases so far at the Justice Center have been ones that have gone really deep into the science, because
Yeah.
that's the climate that we're in right now. That's
Mhm.
COVID, and everything that came after is really dominating a lot of our cases, whether it's vaccine mandates or public health orders. And so there's so much that courts have to understand about the science, and it's not always what you see on the news. I can say that because I'm referring to expert opinion in some of our cases. And I'd encourage people to seek out uh, all sorts of um, credible scientists' um, views, and not only the ones that you see on the news. And it's nice. Sometimes you'll see an article that has different perspectives, and I think those are the best um, media articles, is when a journalist will ask the opinion of two different physicians or scientists on the same issue, so
Mhm.
that the public can see that there's not a uniform consensus on the appropriateness, or um, whether what is being mandated is actually proper or justifiable.
Mhm.
So yeah, I really do thrive off of the science, but I'm very thankful to have people to call to make sure that I'm not getting it wrong. How about
Mhm.
you?
Well, no, it's the same. It's the same thing for me. I enjoy learning. One of the things that, for example, taking someone like Dr. Jay Bhattacharya, one of the great talents that he has that many intellectuals sadly lack is he has this ability to take these complex concepts and pluck them out of the ether and then present them in a way that people who are non-scientists can understand, or at least the essence of them. Certainly not to the level that he can. And there's a certain brilliance to that, a certain clarity to that. And I agree with you that it's very rewarding to meet these people, and who are doing it at great personal risk. One of the things that I found really, really upsetting when I was doing the Ingram case, which is sort of the companion case to the Gateway one that you had conduct of in Manitoba, was the personal attack that was made upon Dr. Bhattacharya, who's a world-renowned expert. Of course, he was attacked by Dr. Fauci and called a fringe epidemiologist, along with experts from Oxford and Harvard and some such schools. But in any case, the essence of the attack on Dr. Bhattacharya was on his credibility. The government lawyers actually tried to frame the argument, and will try to frame the argument, that he is politically biased, and that he lacks any type of pure scientific ethic, based upon the testimony that he gives, and that he gave in cases like Gateway and others. And so they tried to paint him out as somebody who's off on a quixotic vendetta, a political agenda, and the main argument for this was that he refuses payment, if you can imagine that. So this is when that came across the table, I got my back up a little bit, because it's so hard for me to understand why any right-thinking person, rational person, could not see who someone like Dr. Bhattacharya is and what he stands for. He stands for truth and science. And he's concerned about the truth in science and how it affects people, how it affects public health. He's sincerely concerned about the reputation of public health and preserving its role as a means of protecting people from things like pandemic viruses. And so to me, that's the biggest challenge, is just not losing my temper and getting mad at these people for taking these let's say political positions in order to win a case, this net zero sum game. I agree with you that in these cases, the best approach is the one where we can be as objective as possible and try to arrive at the truth of a matter, because then we're doing something important that is of public benefit. But if we're just getting into situations where we're just trying to win a case, to me, that is an inversion, a perversion of the whole purpose of this type of litigation. It's not as though we're fighting over, who's going to get to keep the dog. There's something much more significant at stake here. And I think that when some of these positions stray outside of objectivity, that's the thing that I guess that's the biggest challenge for me. Apart from the same struggles that you face about trying to learn about the different science and the different disciplines, reading graphs and things like that. For someone my age, it's probably good for my brain to do that. but hopefully that answers your question. Well, Allison, we've kept you for quite a while here. I know you have another appointment you have to keep. We're so grateful for your time and for learning more about you and what you do and why you do it. I know how well you do it. I want to thank you on behalf of Canadians, and also as one of your colleagues who works at the Justice Center. I want to thank you for your dedication and your hard work, and how sincerely you believe in the causes that you fight for. And most of all, we just want to thank you for your time today and for being with us. I really think that this conversation is going to be of great benefit to people who take it in, so they can learn more about what's going on in terms of these legal challenges. As you rightly point out, unfortunately, we're living in an era when the media coverage of these cases is biased, and to the extent that this podcast and John Carpe's podcast and others can get this other side of the story out, I think it's very, very important to do that. I know you'll agree with that. And I thank you for being part of that. The last part of our program here to close off is something I call the reading list, where we just try and provide people with some information, an opportunity to learn more about some of the subjects we've been talking about. I've chosen a book that many people might be familiar with. It it talks about, it's called The Origins of Totalitarianism, by an author named Hannah Arendt, and she wrote a great deal about the Nazi period in Germany. And this might seem like an overreaction to some, but I think based upon the conversation that we've had today, the concern about the erosion and the denial of civil liberties it is part of a process. It is part of the emergence of a totalitarian system of governance that is alien to Canadian culture and Canadian politics. So the origins of totalitarianism traces the emergence of modern racism, that should sound familiar, as an ideological weapon for imperialism, beginning with the rise of anti-Semitism in Europe in the 19th century and continuing through the new imperial period of 1884 to World War I. What she goes through in the book is an examination of how really the most educated, arguably the most successful socially, economically nation in Europe, within less than a generation, went from that and to producing some of the greatest thinkers in liberalism and in the Enlightenment, went within a short time frame to being really the scourge of the earth, bent on world domination. And how this was done, psychologically, legally, within Nazi Germany. And I read this book recently, and frankly, I was astonished and horrified to find many of the earmarkings, many of the familiar programs and tactics in terms of what's going on in the media, messages of government, restrictions upon time-honored freedoms such as travel, exposure of people to experimental drugs, for example. Some people might be surprised, but that there was a product called Pervitin in Nazi Germany, which was actually crystal methamphetamine, and it was approved by the Nazi government as a picker-upper, as a medicine, and it was taken by pregnant women. And it was all part of a grand experiment because it was their intention to find a drug that would give soldiers extra pep and energy on the battlefield. And ultimately, Pervitin was in every kit of every Nazi soldier, and this is what allowed the tanks to roll through during the Blitzkrieg. It allowed the pilots and the Stuka dive bombers to be able to dive straight down at the earth without succumbing to G forces. So this is a book that's educational, I think, for Canadians, because there are signs, sadly, that this is occurring in our own country, and we need to be vigilant. We need to be aware. Canada today is not Nazi Germany. It is not the Nazi Germany and Justin Trudeau is not Adolf Hitler. I'm not saying that. However, there are signs that we do have cause to be concerned about the erosion and arguably the destruction of some of the freedoms that we've enjoyed in Canada that have long been part of our culture. And so I recommend this book highly, also because Hannah Arendt is quite brilliant, and she's written a wonderful book. Another book that she's written, I'd also recommend about Adolf Eichmann is also worth reading. Anyway, over to you for the final word, Allison. Do you have any reading material sources that you would refer people to in order to help people expand upon their understanding of some of the topics that you've been discussing today?
Well, I haven't had a lot of time to be reading anything, unfortunately, in the last.
Sure, you've read a lot of books, Allison.
I would recommend people visit. This is not scholarly literature, but I would recommend that people visit Brian Peckford, the Honorable Brian Peckford's blog. He often writes from his experience as one of the drafters of the charter. He has a unique perspective on what's happening in Canada, and he has interesting links on his blog to works that he wants people to read. And he has a very, very unique perspective. And I would recommend that if somebody doesn't have a lot of time to spend going through a a novel or nonfiction, that they take a visit and take a read at what he's saying, to kind of get a sense of where he thinks the country that he has loved and cherished so deeply, how far it's fallen towards a more authoritarian society. And I know personally people who were not really alive to some of these issues or some of these concerns until they heard Mr. Peckford speak. And some people have really come around and had their eyes opened by listening to him, because he's at an age where he has authority and he commands respect, and he's so learned, and he's a voice that I think people ought to be listening to. And so I would recommend they take a visit to his blog to see his perspective on what's going on as an alternative to what they're seeing in the mainstream news.
Well, thank you very much for that, Allison. I concur. His blog is wonderful. And incidentally, for those interested, in our catalog, there is a lengthy interview with Mr. Peckford, which I enjoyed very much. That is worth taking in. Allison, thanks again so much for being with us. I wish you best of luck with all of your cases.
And thank you, Leighton. You're doing amazing work as well, and really appreciate you asking me to come on the show. And I'm sorry it took me so long to get here, but thank you.
Well, it was well worth the wait. Thanks very much.
Thank you.